Good evening, everyone, and welcome to Melbourne Law School. I'm Professor Michelle Foster. I'm the Dean of the Melbourne Law School, and it's my great pleasure to welcome you to the Peter Brett Memorial Lecture for 2025. I'd like to begin by acknowledging that we're gathering this evening on the unceded lands of the Wurundjeri people of the Kulin Nation, and I pay my respects to Elders past, present and emerging. And I extend that respect to any Indigenous colleagues with us this evening. Now, the Peter Brett Memorial Lecture Series is named in honour of the late criminal law scholar Peter Brett. Peter was appointed Senior Lecturer at Melbourne Law School in 1955, Reader in 1961, William Hearn Professor of Law from 1963 to 1964, and Professor of Jurisprudence from 1964 until his death in 1975. Peter enjoyed a distinguished legal career that was characterised by his outstanding scholarship in criminal law and legal philosophy and his determination to contest injustice. Most notably, Peter Brett was part of the group of lawyers who prevented the hanging of Robert Peter Tate in 1962, a landmark in the history of capital punishment in Australia. And we're thrilled to be joined tonight by members of the Brett family. Welcome Karen, Jonathan, Robin, Georgina and her husband Tom. And I hope I didn't miss anyone. So thank you so much for being here. Now, we're privileged to be joined tonight by Professor Lindsay Farmer to deliver his lecture entitled Climate Protest, Political Dissent and the Criminal Law, the Rise and Fall and Rise Again of Conspiracy. Now, the order of proceedings is as follows. My colleague, Associate Professor Peter Rush, will formally introduce our guest speaker. At the conclusion of the lecture, my colleague, Associate Professor Andrew Dyer, will moderate the Q&A, so please do save your questions for the end, and also provide a closing vote of thanks. Associate Professor Peter Rush is an expert criminal law scholar and the author of several books on criminal law, jurisprudence, and post-structuralist legal theory. Peter is Director of the International Criminal Justice Research Program in the Institute for International Law and the Humanities here at Melbourne Law School. Associate Professor Andrew Dyer joined Melbourne Law School relatively recently, following more than a decade's work at Sydney Law School. His research focuses on criminal law doctrine and human rights law and the relationship between criminal law and human rights law, all areas in which he has published extensively. I'd like to remind everyone that tonight's lecture is being recorded and will be available shortly on the Melbourne Law School website. But now I'd like to hand over to Associate Professor Peter Rush to introduce our guest. Thank you, and I hope you enjoy the evening.
I'd also like to acknowledge that this building, the work that we do here, teaching, learning, scholarship and research takes place on the Wurundjeri lands. And I'd like to acknowledge that this gives us obligations which we do our best to fulfill, although not always the case. I'm going to be very brief. I've known Lindsay for, as we were talking before, probably about 40 years now. And we've started our graduate work in England together. And he is a professor currently now, professor at Glasgow University, Faculty of Law, and a fellow of the British Academy. He has a wealth of published research and unpublished research. And if I was to try and briefly describe that, it works across criminal law theory, criminal law debates and the justice of particular cases, as well as the history of criminal law in both England and Scotland. In doing that, he has tried to focus our attention, both historically and in the contemporary field, on the work of institutions such as the criminal trial and also summary jurisdictions, for example. In terms of his specific, more recent focus, it has been on trying to give a new account of the civil ordering of criminal law, largely in relation to England and Scotland, but has a lot of implications for how we think about criminal law in Australia and in Victoria. On that note, he can speak for himself. Professor Lindsay Farmer, please welcome him to the podium.
Well, thank you very much indeed for the invitation to be here tonight, for the very kind introduction, and I really have also, it's an honour to be here to be delivering this lecture, and I've enjoyed very much actually learning also about the work of Peter Brett, and I will comment a little bit on that as I go through the lecture tonight. But first of all, I want to talk about specifically the idea of climate protest and how climate protest and climate protesters are being responded to. I should say, acknowledge here that Alison Young, who's here in the audience tonight, was very much a kind of driver for this lecture when she asked me what was going on when protesters were being prosecuted for under the law of conspiracy. And I didn't know. And because I didn't know, I then became the kind of, the reason to explore this and look at this in more detail. And so I'm going to take you through some of the work that I've done in this area and the kind of questions that I'm trying to ask about the law of conspiracy in this area. But the starting point is the case of R.V. Hallam in 2024. And this was highly controversial in the UK. 5 climate activists belonging to the group Just Stop Oil were convicted of a conspiracy to cause a public nuisance for their involvement in a protest which blocked the M25 motorway around London for a number of hours. The protesters received prison sentences of between 4 and 5 years in prison for their actions. Much of the subsequent commentary has focused on the harshness of the sentences, particularly when compared to other what are judged to be more serious offences. There's been less focus, however, on the question of the use of the conspiracy charge, though that might be the more legally significant aspect of the case, not least because it contributed to the severe sentences. This type of case, moreover, is not unusual, as conspiracy charges are increasingly being used by prosecutors against climate protesters, not only in the UK, but in other jurisdictions as well. A recent report has concluded that the criminalisation and repression of climate and environmental protesters is increasing. Often, this is done by the introduction of new offences, as has happened in several states in Australia, locking on, obstruction of national infrastructure, and so on. But just as often, it's accomplished by the utilisation of existing laws, such as conspiracy laws, to target the practices and networks of climate protesters. So it becomes important to try and understand what the law of conspiracy is and how this archaic and much criticised form of law is being used. In this lecture, then, I want to raise 3 questions about the contemporary use of conspiracy law, or do it in 3 steps. First of all, I'm going to say something about the history of conspiracy, to explain how it is that conspiracy has become a tool for prosecutors around the world. Second, I will look at how conspiracy is being used now and what its use against climate protesters can tell us about the use and abuse of the law more generally. And then finally, I shall offer some suggestions about how we need to rethink our understanding of the law of conspiracy in order to counter these developments. First of all, then, what is the crime of conspiracy? Although there are jurisdictional differences, a conspiracy is generally constituted when 2 or more people join together for the purposes of committing a crime. It is regarded as a form of inchoate liability, like a liability for attempts. But what's distinctive about the law of conspiracy is that it's the conspiracy itself, that's to say the agreement, that is the crime. In principle, this means that the crime not only does not have to be completed, only that some sort of overt act has been undertaken by one or more of the conspirators in furtherance of the conspiracy. The rationale for the crime is generally seen as the idea that conspiracies pose distinct risks which are greater than those posed by individuals acting alone, because of the dangers of deliberate plotting and the greater threats posed by groups. This is often captured in the claim that the use of a conspiracy charge will reflect the greater overall criminality of the conduct, something I'll come back to later on. The main criticisms of the law of conspiracy are well known. In fact, when I said I was going to talk about conspiracy in doing this lecture, many of my colleagues said, well, what are you going to say about conspiracy? It's all been said. All the criticisms are well known. The criticisms are largely as following. Members of a group might be punished for something they could not be punished for as individuals. Members of a group might be convicted of conspiracy, even where they've not agreed on the means by which the conspiracy might be carried out. Evidence against one participant can be used as evidence against all other alleged participants. And the charge of conspiracy might be used by the prosecution to give a semblance of unity to a number of otherwise disparate actions. It is, as Peter Brett and Louis Waller pointed out in the early editions of their casebook, a form of constructive liability, where engagement in one form of conduct generally grounds liability for another potentially more serious crime, and as such is open to the objections which are made to constructive liability. It's not for nothing, then, that the crime of conspiracy has been described as the prosecutor's darling. So what about the history of the law of conspiracy? In England and Wales, the history of the law of conspiracy is conventionally presented as a rise and fall. The crime has its origins in medieval English law, where it was a means of criminalising malicious prosecutions. The scope of the crime was expanded over the course of the next few centuries, such that by the 18th and 19th centuries, it was recognised that conspiracy extended not only to an agreement to commit a crime, but also to agreements to achieve a lawful object by unlawful means. The law of conspiracy in this form was widely used to suppress trade union activity, Irish nationalism, and other forms of political dissent over the course of the 19th and 20th centuries. In England and Wales, a series of cases in the 1960s and 1970s where conspiracy charges were used to enforce a conservative view of sexual morality generated a huge amount of criticism, and the law was reformed in the Criminal Law Act 1977. This largely, if not completely, abolished the common law offence of conspiracy, replacing it with a new statutory form of conspiracy. And subsequently, conspiracy has been seen as a technical and largely uncontroversial aspect of the criminal law. This is the fall. Thus, to quote from a leading treatise, that's the one that's on the slide here, conspiracy charges used to be the bogey of the political left because of their use against people who take part in industrial and political disorder. But considerable changes have been made in the law, and at the present day, the charges are neither so oppressive nor so efficacious as prosecutors seem to believe. Now, remarkably, this story of rise and fall is, with minor variations, repeated in the criminal law of many other Anglophone common law jurisdictions. Although the picture is slowly changing, Australian textbooks, for example, cite mainly English cases when discussing the law up to the middle of the 20th century, while also suggesting that the excesses of English law were largely avoided in Australia, and that the proposed English reforms in 1977 were merely going to bring English law into line with Australian law, what Australian law was already doing. And where Australian law has been codified, it's also done mainly on the basis of the pre-existing common law. So it simply reproduces the concepts from the pre-existing common law as well. We find a similar story in Indian and Canadian textbooks, which I've looked at, and a widely cited article on the development of US law by F.B. Sayre, published in 1922, is likewise devoted to the analysis of English cases. And contemporary US law is not substantially different from the law of other common law jurisdictions. So we get this picture then of conspiracy being largely framed in similar terms across the range of common law jurisdictions, but also that it's seen as uncontroversial or not generally raising any problems. But this raises, I think, two really important questions. First of all, what is the significance of this common pattern of development? How, if at all, might it be of assistance in thinking about contemporary developments? And second, is this claim that conspiracy law is now largely uncontroversial, its abnormal and problematic aspects left in the past, is this an accurate claim? Can we talk meaningfully, in other words, about the rise and fall of conspiracy? Or should we be concerned that it's rising again, or indeed that it never declined? In addressing the first of these questions, I want to suggest an alternative genealogy of conspiracy law by looking at its development in a wider frame, not only in England, as is commonly the case, but in the British Empire. Here, we find not only that English law was spread across the empire to what is euphemistically referred to as the common law world, but also that these English laws were routinely deployed against political dissenters or opponents of empire. And to explain this development, I'm going to pick out three episodes which demonstrate the different ways in which the law of conspiracy was spread across the British Empire. So first of all, in Sydney, the Sydney 12 in 1916. In September 1916, 12 members of the industrial workers of the world were arrested in Sydney for their alleged involvement in a series of arson attacks. And they were eventually charged with conspiracy to commit arson, seditious conspiracy, and conspiracy to pervert the course of justice, with the seditious conspiracy charge being seen as linked to their opposition to conscription during the First World War. All 12 of the men were convicted and sentenced to prison terms of between 5 and 15 years with hard labour. In upholding the sentence, the Court of Criminal Appeal argued that seditious conspiracy was an attempt to subvert, and here I quote, an attempt to subvert all law and order and set up a state of anarchy in the community, and as such was more than any civilized society could tolerate. The men were eventually released following a public campaign which led to a royal commission in 1920. A similar pattern can be seen in the prosecution of union organisers that followed the Winnipeg general strike in 1919. After nearly 30 days of the strike, 10 union leaders were arrested, and they were also charged with seditious conspiracy. The state alleged a communist conspiracy to overthrow the government, stoked by fears of the Russian Revolution. And this was evidenced in the prosecution case by speeches made by the organisers and their possession of pamphlets and other subversive political literature, such as the Communist Manifesto and some writings of Lenin. The prosecution thus asserted that the men had seditiously conspired to, and I quote, bring about discontent and dissatisfaction, and what would be the logical result someday? Revolution. The case, in effect, rested on the assertion of a pre-existing global communist conspiracy to overthrow established government, which the defendants had participated in through their conduct in the strike. Notwithstanding this, the men were convicted and received long sentences of imprisonment. The crime of seditious conspiracy itself has its roots in the prosecution of Irish nationalists during the 19th century. The indictments in these cases typically alleged a conspiracy to excite unrest or disaffection, as manifested by speeches made or the holding of political meetings. The element of agreement was the formation of a political organisation or society. So the formation of the organisation or the holding of meetings was treated as in itself evidence of the existence of a conspiracy, without the need for anything more. And while there's much that can be said about these cases, I want to note that while they were clearly politically motivated prosecutions, they played a key role in the development of the doctrine of conspiracy. The case of Mulcahy in 1868 in which Mulcahy and 19 others were convicted of seditious conspiracy, gave rise to one of the most widely cited modern definitions of conspiracy. This is the statement by Mr. Justice Wills that, and I quote, "A conspiracy consists not merely in the intention of two or more, but in the agreement of two or more to do an unlawful act, or to do a lawful act by unlawful means. So long as such a design rests on intention only, it is not indictable. When two agree to carry it into effect, the very plot itself is an act, and the act of each of the parties punishable for a criminal object." And what's important about this is in textbooks, this is generally cited as a form of protection for the accused person, right? It's not just the agreement. You have to do something in prosecution of the agreement. But when you see how this is actually used, that the doing something was holding a meeting and making some speeches, then you see this is not something that is a protection at all, but is actually something that is enabling. And it's something that enabled the spread of the idea of seditious conspiracy across the British Empire, and Mulcahy was cited in the Sydney cases and the Winnipeg cases as well. So the criminal law was the common law was thus establishing generalizable concepts which were applied throughout the world. Move on to my second example. We have a great picture here of a bomb going off behind an elephant. And this is on the 23rd of December in 1912, the British Viceroy of India, Lord Hardinge, was taking part in a state procession in Delhi, the new capital of India, when a bomb was thrown from a nearby building. Hardinge and his wife were injured, and an attendant were killed. In the aftermath of the explosion, blame fell on a presumed conspiracy, and the assumption of this conspiracy was so widespread that assurances were sought in the Westminster Parliament from the Under-Secretary of State for India that all steps were being taken to unravel the organised conspiracy behind the attack. So it was the conspiracy that was blamed here rather than the failures of policing that led to the bombing. So it was not a surprise then when in March 1913, the British government proposed an amendment to the Indian Penal Code, which had been enacted in 1860, which would introduce a general offence of conspiracy. In the words of Sir Reginald Craddock, introducing the bill to the Indian Legislative Council, this aimed to bring the law of India into line with the law of England, and was justified, he argued, because as society became more developed, new kinds of conspiracies developed, which were more secret, more devious, and which posed a greater danger to peaceful citizens and to society at large. Notwithstanding objections from some members of council to the haste with which the law was being introduced, the law was passed, bringing to India, I quote again from Sir Reginald Craddock, a law which has been found most necessary and most salutary in so advanced and law-abiding a country as England. Now, Macaulay's original penal code, which was published in 1837 and enacted in 1860, had been striking in that conspiracy was defined in much narrower terms than the common law. It was defined as a species of abetting only, so assisting another person in committing a crime. And it was a form of assistance in committing the other to commit a crime. There was no general offence of conspiracy. So it wasn't just criminalising agreements as such. Although it's also worth noting that the code as enacted did criminalise dacoitery, which was defined as 6 or more persons joining together for the purposes of robbery as a form of conspiracy. The 1913 amendment, though, was consequential, not only for the law of India, where it's been widely used since, but because the Indian Penal Code then became the model for jurisdictions across Asia and Africa, where such provisions still survive to this day. A third example, the Fenian Dynamite Campaign from 1881 to 1885. I will get on to climate protesters in a minute. So, on the 28th of May in 1883, 6 Irishmen were put on trial at the Old Bailey on charges of treason felony for planning to blow up the Houses of Parliament. The men were alleged to be members of the Fenian Brotherhood, which at the time was carrying out a bombing campaign on the British mainland, targeting government buildings, the railway network, newspaper offices, and so on across the country. The men were found in possession of large quantities of chemicals and the kind of paraphernalia for making bombs. The prosecution case was that there was an elaborate international conspiracy to manufacture the explosives and cause the bombing, although conspiracy was not an explicit part of the charges against the men. 4 of the men were found guilty and sentenced to penal servitude for life. Interestingly, though, shortly before the trial started, on the 10th of April 1883, the UK Parliament passed the Explosive Substance Act, Section 3 of which criminalised conspiracy to cause explosions of a nature likely to endanger life or cause serious damage to property, an act which is still in force today. And this is important because it's an example of parliaments passing what we can refer to as special conspiracy laws, not a general crime of conspiracy, but special laws which criminalise conspiracy to do certain kinds of actions. But these build on and use the common law concepts of conspiracy in doing so. So they exist alongside the general offence. So I'll give you just a few more examples to show how widespread this practice became subsequently. First, and perhaps most notoriously, there's the Internal Security Act 74 of 1982 in South Africa, one of the most notorious security statutes of the apartheid regime. This act, which consolidated earlier legislation, such as the Suppression of Communism Act 1950, criminalised terrorism, subversion, and sabotage. The Act defined a range of anti-state activities in very broad terms, such as inducing the government of the Republic to do or abstain from doing any act, or to adopt or to abandon any particular standpoint. And they made conspiring to do such an act criminal and subject to severe penalties up to 25 years imprisonment. There's similar legislation to the in India, where the Unlawful Activities Prevention Act 1967 prohibits conspiring to commit a terrorist act or acts preparatory to the commission of a terrorist act. Also in India, the Narcotic Drugs and Psychotropic Substances Act 1985 criminalises abetting or being party to a criminal conspiracy to commit an offence under the Act. In the UK, the Criminal Justice Terrorism Conspiracy Act 1998 criminalised conspiracy to cause a terrorist act outside the UK. And in Australia, we can note provisions in the Commonwealth Criminal Code and state criminal laws that address conspiracy to commit offences, specific offences such as conspiracy to defraud the Commonwealth or to pervert the course of justice. So what we see then is through these 3 modes, the spread of the common law, the codification of the common law, and it's the adoption of codes throughout the empire, and the adoption of the introduction of these special conspiracy laws, we can see how they operate in tandem and spread the doctrine of conspiracy throughout the empire. I want to turn now to look at contemporary uses of conspiracy. And I've tried to give an overview up to now of how the law of conspiracy has developed and how the development of the law has been driven by specific kinds of cases where conspiracy has been charged involving forms of political resistance. I want now to shift the focus to ask how conspiracy is used today. And is it possible to argue, as was suggested earlier, that the political and problematic aspects of the law have been purged? Now, the first point that I want to make here is that it's actually very hard to tell. I was astounded to learn that in England and Wales, conspiracy was charged in 9,109 offences in 2023 to 24. This is an increase from 7,800 cases in 2014-15. So there's evidence of some sort of increase in the number of cases where conspiracy is being used. But this was not publicly reported information. And I had to get it by making a Freedom of Information request. And I understand that it's also common, I know, in India, I suspect also in Australia, that numbers of conspiracy charges are not separated out in the criminal statistics. So we don't know, actually, how much conspiracy law is being used or what the kind of law usage might be. We don't know whether prosecutions relate to climate protesters, to drug gangs, or other types of offenders. In England and Wales, equally, the Crown Prosecution Service doesn't provide any specific prosecution guidelines as to when conspiracy might be charged. So it's not possible to know when and where its use is considered appropriate, or if any restrictions to its use exist. These numbers would seem to challenge the idea that conspiracy law is in any sense in decline. What has perhaps declined is the sense that conspiracy laws are controversial. Indeed, it's striking that the last time there was any significant academic engagement with conspiracy laws was in the 1970s, prior to the amendment, the 1977 Act in England and Wales. Since then, there's been little discussion or a focus only on technical aspects of the law. So the question of what is or is not normal is very difficult to gauge. However, if we turn to look at how conspiracy law has been used against climate protesters, we can see some further features of its use. In the UK especially, the laws are increasingly being used to police protests, and in ways which infringe, arguably, the right to public protest. In addition to the Hallam case, a further 27 Just Stop Oil protesters were arrested on suspicion of conspiracy to disrupt national infrastructure for plans to disrupt UK airports. 114 protesters were arrested in April 2009 and charged with conspiracy to commit aggravated trespass to prevent mass protest at a power station. And only last weekend, the Metropolitan Police raided a Quaker meeting house in London to arrest 6 members of the group Youth Demand on suspicion of a conspiracy to cause public nuisance. In 2025, in Perth, Western Australia, a group of protesters against Woodside Energy were arrested by counter-terrorism police outside the home of the chief executive of the company and were initially charged with conspiracy to commit criminal damage. I'm broadening this out a little bit further. 20 people protesting at, 20 people protesting at the coronation of King Charles in May 2023 were arrested on suspicion of conspiracy to cause a public nuisance. And they were found to be in possession of glue, a banner, and some Allen keys, which were judged likely to have caused disruption. I'm not quite sure what form that would take. We see evidence here, then, of preemptive policing, and the allegation of conspiracy is used to arrest and remove protesters before they have the opportunity to participate. While this may be legitimate if there is clear evidence of a credible threat, it's far from clear that this is always the case. What is clear is that the language of conspiracy frames the motivations of protesters in a negative way. To conspire is not to protest, is not to have a reasonable excuse for your conduct, but it insinuates involvement in something much more clandestine and threatening. And it's of the nature of conspiracy that even if we don't know the object of agreement or association, that's merely because we haven't yet uncovered or understood that object, the kind of the conspiracy theory that underlies conspiracy charges. So we might ask why there is this resort to conspiracy, given that the police are generally in possession of other broad powers to arrest people or to contain protest. Here it's been argued that conspiracy is used strategically because it enables other powers which are not available if arresting for a lesser offence. Notably, the power to search premises under the Police and Criminal Evidence Act, 1984. In other areas where conspiracy is used, conspiracy is frequently charged as a means of escalating the seriousness of an offence so as to bring it within the scope of proceeds of crime legislation, and so to be able to seize assets of the guilty person. In addition to this, Where conspiracy is charged, even in cases where the crime has been completed, as was the case in Hallam, and anecdotally seems to be the case more generally, this may be because it's argued that the charge represents the greater overall criminality of the conduct. This phrase has not been defined, but it suggests that the conspiracy charge can act as a kind of aggravation or multiplier, leading to more severe sentences. And again, while there's not necessarily anything illegitimate about this practice in itself, the problem may lie in the fact that the precise circumstances under which the resort to such aggravation may be justified have not been defined. How is this overall criminality measured? Is it tied to the involvement of more than one person, in which case it's circular? Is it linked to the object, for example, the amount of harm which is caused, or the conduct of participants? There might be different ways of thinking about overall criminality, but if it's to act as any sort of restraint on prosecutors, we would need much more clearly defined guidelines as to when it would be appropriate to use it. It's also striking that in cases like Hallam, for example, and others like it, the judge repeatedly refers to the defendants as fanatics, which implies criminality rather than a reasoned form of action. A further point that I want to note is that the charge of conspiracy is frequently used in tandem with vague or open-ended offences. In Hallam, the charge was conspiracy to commit public nuisance, a notoriously broad and catch-all offence. And this, we should note, is in the tradition of the development of seditious conspiracy, which I've discussed earlier. This practice is also characteristic of the use of conspiracy across other jurisdictions. In India, in 2010, the healthcare activist Dr. Binyak Sen was convicted of sedition and conspiracy and sentenced to life imprisonment. In Rwanda, in 2013, opposition leader Victoire Ingabire was convicted on charges of conspiracy to harm the authorities by denying the 1994 genocide. And as a final example, a neglected feature of the recent trial of dissidents in Hong Kong under the Chinese national security law was that the defendants were charged with a conspiracy to commit subversion. So the subversion was defined under the national security law, but conspiracy was the English law of conspiracy as it had been codified in Hong Kong in the 1990s. Broadening the picture further, I want to note two developments from the US which suggest a further intensification in the use of conspiracy laws against climate protesters. The Mississippi legislature has recently passed a law to protect critical infrastructure against protests which criminalize... I'll start again. The Mississippi legislature has recently passed a law to protect critical infrastructure against protest, which criminalizes organizations that aid, abet, solicit, compensate, hire, conspire with, or command or procure a person to commit the crime of impeding critical infrastructure, subject to a fine of up to $100,000. What's striking about this, as well as the number of different ways that organizations might assist or act with other persons, is that the organization is in effect defined in advance as a form of conspiracy, such that it's hard to know how organizers might avoid liability. The second example I want to use is the use of legislation ostensibly designed to target terrorism and organized crime being used against environmental defenders. In the American state of Georgia, 61 protesters trying to prevent the destruction of the South River and Willowney Forest in order to build a police training center known as Cop City were charged with criminal conspiracy under the state's RICO laws, that's racketeer and corrupt organization laws. And in the words of the ACLU, the indictment relies on people's beliefs and community organizing as the connective tissue for sweeping criminal liability, painting the provision of mutual aid and the advocacy of collectivism as hallmarks of a criminal enterprise. Now, while these are clearly extreme cases, This points to the fact that almost any form of organisation can potentially be seen as a conspiracy. And indeed, that precisely those things that protesters might do to coordinate protests can be turned against them under conspiracy laws. Now, this is obviously a partial picture, but what it suggests is that the current use of conspiracy laws is at least in part consistent with the prior pattern of development, and that we should be wary about suggesting that the law of conspiracy is in any sense in decline, or that it's only used in uncontroversial ways. So we come then to the conclusions. Now, I began the lecture by commenting that criticisms of conspiracy law were well known. And there's a remarkable consistency in the criticisms of the law, both over time and across different jurisdictions. It's clear that the law of conspiracy is a powerful and often dangerous tool in the hands of the state, and that this is the case notwithstanding occasional efforts to constrain or limit the law. As the quote from Peter Brett and Louis Waller that I put on the slide suggests, they say, "Of what use is it to tell a prosecutor that he ought not to eat a rich and tempting meal which you set before him on a platter?" As this quote suggests, we should not perhaps blame prosecutors for the failure to resist if such powerful tools are put at their disposal. But it does raise the question of what should be done. And in concluding then, I want to make 4 points about the importance of engaging with the law of conspiracy, and even arguing for a new agenda of research in this area. First of all, if we look at the law of conspiracy from the perspective of the present day, what we see is an extraordinary variety and range of offences across the globe that have developed out of an obscure English medieval doctrine. Conspiracy is a crime that is used across the world, not only in England and Wales, but in almost every post-imperial state. And it's worth noting in passing that conspiracy does not generally exist as a crime in civil law jurisdictions. They rejected it. But while the roots of the doctrine are in English law, it's now, I think, time to move away from a focus on those roots and to begin to track how it is used. Second, at the same time, it's clear that we know very little about the way that the law of conspiracy is used. To take only England and Wales, as I've shown, numbers of conspiracy prosecutions are not disaggregated from general statistics, and this seems to be the case in other jurisdictions as well. We also don't really know how the law is being used. This might relate to the subject matter of prosecutions, climate protest, political crimes, organized crime, financial crimes, or something else altogether. We also don't know how it's used by the police, and how I mentioned earlier the anti-terrorist police, in Australia enforcing it against protesters. How are the police using conspiracy charges? And this is something that I think we need to gather more information about. There's also an important question of whether the law is being used primarily as a form of inchoate liability, like attempts, as it's traditionally been characterized, or whether it's being used as a form of participatory liability, where the crime has already been completed. While it continues to be discussed and analysed in criminal law theory as a form of inchoate liability, it would appear that it is often in practice used as the former, which would have important implications for how we think about the law. The more general point here, however, is that it's crucially important that if we want to prevent injustice, we need better information about policing and prosecution. Third, a consistent theme of the literature around conspiracy law is that if the crime has a rationale, it is that conduct by groups or associations poses a greater threat to order than individuals acting alone. This claim is rarely substantiated. But rather than just repeating the standard criticisms of the claim, I want to make a slightly different point. The recent rise of conspiracy points to a broader development in contemporary criminal law, which is the development of a range of different forms of group liability, or what have been called conspiracy-related offences. While the terminology might vary between jurisdictions, these would include assisting and encouraging crime, joint enterprise liability, consorting offences in Australia, arranging or facilitating child sex offences, certain kinds of terrorism offences, anti-bikie legislation, again in Australia, RICO offences, even corporate liability, and so on. The point here is not just that there is perhaps less need for a conspiracy offence given the plethora of other offences which criminalise group action conduct in this area, but that a shift might be but it's that this is indicative of a shift in the criminal law, in the focus of the criminal law, away from individuals and towards forms of group liability. This shift might be taking place for a number of different reasons, but what is important here is that, as Brett and Waller recognised long ago, these are frequently forms of constructive liability, where liability for a more serious crime is based on forms of association with others. I would argue that conspiracy should be analysed in the context of these developments rather than in terms of the old textbook classification of inchoate liability. Finally, I want to say something about the term conspiracy itself. As long ago as 1873, R.S. Wright, in his seminal treatise on the law of conspiracy, was arguing for the use of a more neutral terminology. Rather than having a general offence of conspiracy, he argued it was more important to define the offence in terms of agreement to commit a crime, and then for the law to focus on specific types of agreement and the different kinds of threat that they might pose. This, if anything, is a more pressing point now. I've tried to show that the language of conspiracy has been used, as it were, to call conspiracies into being, and the supposed threat of conspiracies then justifies repressive action by the state. The imaginary of conspiracy is of something sinister, secretive, and political, while the reality is often no more than participation in some discussion or loose organisation. There may well be dangerous organisations, and there may even be a need for a crime of this kind, but the language and history of conspiracy is an obstacle to rational discussion. To finish, I want to mention a quote from Peter Brett from his book, An Inquiry into Criminal Guilt. In this book, he commented that the criminal law was based on a 17th century philosophy and an 18th century psychology. Very true. The law of conspiracy, we might argue, is based on a medieval conception of the threat of groups, which is coupled with 21st century law enforcement machinery. I've tried to identify some of the consequences of this combination. But this is only a first step if we're to stop the rise of conspiracy. Thank you very much.
Thanks for that. You talked kind of very clearly about the expansion of conspiracy, through various means as a result of kind of notorious incidents. I'm wondering if you can elaborate a bit on where it's declined or shrunk, either because of public pressure or wins in court.
Thank you. It's an interesting question. I mean, the main shrinkage, if you like, was in the 19th. I can talk with more knowledge about, obviously, the law in England and Wales than say Australia. There were notorious cases in the 1960s and 1970s in which first of all, a man who was publishing a directory of prostitutes or sex workers in London, known as the Ladies' Directory, was prosecuted for so-called conspiracy to corrupt public morals. And this was a notorious prosecution, both because of the use of the conspiracy charges, and also because there was some debate about whether or not it was actually a crime to corrupt public morals, whether that actually was a crime that existed in the law before the prosecution. And so he was convicted, as is often the case, and the House of Lords held that there was this residual power to convict anything that offended public morality. And this became very much a kind of cause célèbre through the 1970s, 1960s and 1970s, which are often seen as the decade of permissiveness, or when certainly attitudes were changing in the post-war period. So this was the main case that started that off. There was a later case then, later cases in the early 1970s. One there's an interesting case called Nuller, which is where the House of Lords sort of gave with one hand and took away with the other. Or they seemed to be limiting the case, but they upheld the conviction against the accused person. But what was also interesting, there were in a sense of empire coming home, there were protesters who occupied the Sierra Leone mission in London, who were charged with conspiracy to trespass. And in that case, the House of Lords actually did come out and say that there was no such thing as conspiracy to trespass. And that was a very rare instance of the House of Lords resisting. The restriction, such as it was seen as coming with the 1977 Act. Although, in fact, it was the main restriction was that rather than saying a conspiracy could be an agreement to commit a crime or an agreement to commit something that wasn't a crime by criminal means, they took away the second leg of that definition in the Act. But they actually left conspiracy to defraud, conspiracy to corrupt public morals, and so on. So these all remained in the law, and so there wasn't that much change. So the kind of, I guess the point would be that what is often told as this story of decline and restriction, actually, if you look more closely at it, was nothing of the sort. It was very limited changes in the law. But what really happened was that attention moved away from it. And I find it remarkable that, the 1960s and 1970s, there were several books published about conspiracy. The book in Australia, Gillies, The Law of Conspiracy in Australia. There were numerous articles written about the law of conspiracy. Since then, and I've been searching, I've found about 3. And it just drops away altogether. So what's happening here? So I think it's important that for the academics in the audience, it's important that we think about how to re-engage with the law of conspiracy and the issues here.
Thinking about what is driving this increase in conspiracy, would it be generally true to say that governments have found a very convenient means for intimidating or closing down even organisations and causes that they don't believe in? I mean, if you're looking for general patterns, would that be true?
Yeah, I think probably that is true. I mean, I think that there is, I mean, it's not always done by the use of the law of conspiracy. And so I mentioned at the beginning of my talk a report on the use of the law against climate protesters. And in that report, Australia is identified as one of the most active countries, along with England and Wales, you'll be pleased to know, for passing legislation which is criminalising different forms of protest. So it is very clear that certain kinds of protests are increasingly seen as illegitimate, and the criminal law is being used as a weapon against that. But even if the laws aren't enforced, it has then a kind of chilling effect, because very often the police tactics, it enables certain kind of police tactics, and as I say, it becomes a kind of as is happening in England and Wales. I'm not sure this is the same in Australia, where conspiracy charges perhaps not being used as much against climate protesters. It's used because it enables other powers of search and of sentencing and so on.
Thanks. Thank you, Lindsay. That was great. I'll keep it very quick because I know there are other people who had their hands up. But I was wondering if what do you think about the ways in which some of these charges come to the events that are relating to the charges come into the purview of the police? With Hallam and others, a journalist went undercover, masqueraded as a protester and took part in the meeting.
The Zoom call. It wasn't even a meeting.
It was a Zoom meeting. So ideas of going undercover or infiltrating and so on seem to reinforce the idea that simply having a meeting becomes evidence of a conspiracy. So the journalist doesn't get charged with fraud or anything for pretending to be a climate protester when they're simply looking for a story. But I just wondered if you could comment on the way that evidence constitutes conspiracy and the way that the police collect that evidence, because they're not usually in the meetings themselves, although that's a tactic that I think could be developed.
Yeah, I could have said more about this, but another of the features of the history of the law of conspiracy is the use of agents provocateurs and undercover spies, essentially, and that we find going right back to the 1790s, in particular, and the prosecution of Irish nationalists. So it's a long-standing feature of the law. And of course, it's enabled by the law because the legal threshold is so low in these types of cases. So I think it's a very important issue. It's also interesting. You say the police are often not there. In one of the cases I mentioned, the police were there because it was one of the undercover police officers, Mark Kennedy, who was actually in the group that was organising the trespass on the power station. So it is. That's why I wanted to finish by saying it's the combination of the enforcement machinery and the law that is part of the problem here, and there needs to be a focus, I think, on both of these things. It's not just a matter of reforming the law, but looking at the enforcement.
I think we have time for a couple more questions. I think up the back.
Yeah, thanks for everything you've shared so far. Can you speak a little more to the implication on this law to climate protesters in Australia at the moment, and what kind of protest is more or less likely to have this charge?
So, it's an interesting question, and from what I've been able to see so far, and I've spoken to various people about this, conspiracy charges are not as widely used in Australia as in England and Wales. That's the good news, all right? The bad news is that perhaps the police don't need to use conspiracy charges because they have all these other powers that they're using instead. I do wonder, and if anybody in the audience has the answer to this, then please tell me afterwards. As I suggested, one of the reasons why conspiracy charges are used in the UK because it's a serious crime, which then enables other police powers of search and so on. Now, there may not be a similar triggering relationship in Australia, and so it would depend on how the law is formulated, and maybe the police have those powers anyway. I think, what is, even knowing very little about it, what is clearly a kind of focus for concern would be the use of anti-terrorist police in policing climate protests, because whatever else it is, it's not climate protest. It's not terrorism that is generally being planned. But that also points to the kind of family of offences that I finished by kind of saying we're all grouped together. And so it's not looking at conspiracy charges in isolation, but the different ways that organisational or group conduct can be criminalised and what that means, again, and in its relationship with law enforcement. So it's a little bit vague, perhaps. Hopefully the spread of conspiracy charges in this way won't come to Australia, but conspiracy charges are widely used, and in the jurisdictions I've looked at, they are widely used in India. They are widely used, we saw in the US. And I'm not sure about Canada, but there's no reason, perhaps on the face of it, why they wouldn't be, and that would be obviously a significantly worrying development.
Thank you for your talk. You've mentioned several times that it's difficult to get information out of police and court systems. Do you think AI might help in this issue?
I simply don't know. I mean, it may be that it would. I mean, when I made the freedom of information request, the answer I got was that it was too expensive to disaggregate the different offences. It may be that if AI was used, it could perform that task more quickly and easily. I suspect that when they say it's too expensive, that's also an excuse. They don't want to publish the information, and so that you know the money is or AI would not necessarily solve all the issues here.
Is this actually the outcome of a grand conspiracy by IT professionals to create courts management and police information systems that are impossible to interrogate?
Well, there are issues around the world about getting access to organisations like that, and maybe AI might make a difference, but I don't know.
I think we can have one last question. Right up the back, thank you.
Thanks very much for a fascinating talk. I found it particularly interesting when you were saying, when you were talking about how conspiracy charges are often coupled with particularly open-ended offences. Would it be fair to characterise your view as saying that kind of the extent to which conspiracy is problematic is proportionate to the extent to which the criminal offence that it's coupled with is problematic? Or are you saying that there's something over and above, something inherent about conspiracy that's problematic? And perhaps, or maybe a third option is that insofar as we're going to, if we take it as given that we're going to have open-ended problematic offences, that then we should really be concerned about conspiracy as a way of avoiding some of the particularly problematic outcomes with those offences it's attached to. Thanks.
Okay, thank you. So I think, I mean, my view would be that there is something which is problematic about conspiracy, and when it's used with open-ended offences in particular, it's like a double multiplier, because it's conspiracy to do something, but actually proving public nuisance or sedition is in itself so open-ended that it makes it serious, and the conspiracy makes it more serious. So the aggregate effect is even worse. So one of the other problems is simply that many of these open-ended offences would be enough on their own. The protesters in Hallam could have been charged with public nuisance. You didn't need to charge conspiracy, or it wasn't clear why conspiracy was added to that. And I would say probably 90% of the cases that I discussed today, that would be the case. There's grounds to charge the target offence, as it were, or to charge an attempt to commit the further offence. So conspiracy is it's not really clear in a sense what it's adding, other than it's adding to the sentences that are imposed at the end of the day. So I do think that is the real issue that needs to be focused on here.
Thank you very much, Professor Farmer. It's been fantastic to hear from you. It was a really stimulating speech, as I said before. And thank you also, everybody, for coming along tonight and asking those questions at the end. We have refreshments being served after proceedings tonight, so please do hang around. But please also thank Professor Lindsay Farmer for his talk.